Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. Welcome everybody this afternoon to this ADR Services Inc. in-house program, litigating and resolving Marvin claims. Thank you so much for joining us today, and thank you for our fantastic panel for joining us and putting on this presentation. So I'd love to introduce our speakers today. Again, we are presenting today on litigating and resolving Marvin claims. Our first speaker is Judge Elizabeth Feffer. Over 13 years of judicial service, Judge Feffer presided over more than 75 civil jury trials, more than 500 civil bench trials, hundreds of evidentiary hearings, and numerous settlement conferences. In addition to her civil court assignments, Judge Feffer served 4 years in the family law division, where she presided over issuing rulings on thousands of cases involving all types of complex family law matters. Lauded for her eloquence and exceptional legal knowledge, Judge Feffer is known for her thorough preparation and ability to connect with litigants. Her patience, compassion, and dedication have helped establish her reputation as an even-handed and esteemed jurist. And now, as a neutral with ADR Services Inc., Judge Feffer utilizes that excellent legal background to specialize in a number of areas, including employment litigation, professional liability, family law, of course, personal injury, elder abuse, business litigation, partnership dissolutions, insurance bad faith, eminent domain, and entertainment cases. Thanks so much for leading our panel today, Judge Feffer.
Thank you for having me.
Wonderful. Next up, we have Daniel Paluch. Daniel is an exceptional and experienced litigator with a record of success representing businesses and individuals in complex litigated matters in state and federal court. His multifaceted expertise covers torts, breach of contract cases, finance and lender liability disputes, residential and commercial real estate matters, IP claims, consumer protections, family law, and trust and estate controversies. Daniel is also among the nation's most experienced property assessed clean energy or PACE financing litigators, having personally handled an excess of 80 PACE-related cases on behalf of PACE financing providers and their government partners. Thanks for joining us today, Daniel.
Thank you.
And finally, we have Suzanna Papazyan. Suzanna has previous experience as an associate attorney practicing family law, and she brings a wealth of knowledge on divorce, separation, child custody, visitation, child and spousal support, and other family-related matters to her family law firm. Suzanna is devoted to assisting families to find solutions in challenges that can occur during divorce and other family law related matters. She also has experience with helping individuals who are faced with issues such as bankruptcy and debt during times of family crisis. Thank you for providing the family law perspective today, Suzanna. Glad to have you.
Thank you. Glad to be here.
All right, without any further ado, I will hand it over to our speakers. Judge Feffer, if you'd like to get us started.
Yes, briefly, thank you. And again, thank you everyone for being here. We really appreciate it. And we have a really great presentation. I know how many of you have already clicked onto the case materials and the course materials that we have. It's a very good source of information, including like a Marvin cheat sheet. So why do we have a civil litigator and a family law litigator on this panel? You know, aren't Marvin claims civil? Well, yes, they are, but I'm sure I'm not the only one to have this, you know, law school experience. I mean, my 1L contracts class was a year long, and we didn't touch on Marvin at all. Yet I learned about Marvin in law school from my community property class, amongst all of the other, you know, California family law cases. So even in the way law schools teach Marvin actions, at least my experience has been, it's family law kind of in nature as opposed to contract in nature. And of course, when many of these are litigated, and I could speak to the experience, you know, in the LA Superior Court, many of these cases have a family law lawyer and a civil litigator consulting on these cases. So it's very important to get both perspectives, and I'm thrilled to have two extraordinarily experienced litigators in that area. So with that, Suzanna, did you want to kick it off, the discussion of the Marvin law?
Yes, great. Thank you, Judge Feffer. So before I get into the substantive aspects of Marvin claims, I think it's important to briefly go into the history and the context in which these claims came about. So as I'm sure many of us know, there's no common law marriage in California. It's long been eradicated. What this means is that simply living together and holding yourself out as a married couple is not going to be enough to create a valid marriage with enforceable legal rights. Non-marital cohabitants in California, no matter how long they've lived together, no matter how long or how marriage-like their relationship was, are not entitled to community property or to spousal support under the family code. However, as we're going to see, the California Supreme Court in the seminal case of Marvin v. Marvin determined that although these non-marital cohabitants may not have rights under the family code to community property or to spousal support, they may have enforceable contractual rights that arise from their relationship. These rights, as Judge Feffer mentioned, are adjudicated by bringing a civil action. They are not governed by the family code. So the idea behind Marvin actions has been around in California for quite some time. The foundations were laid way back in the early 20th century. The Marvin cheat sheet handout that everyone got today as part of the program lists several of these notable Marvin cases, including many cases that were decided pre-Marvin. These pre-Marvin cases that I have up on the slide they laid the groundwork for the enforceability of these agreements regarding property and support between non-married cohabitants, and effectively they set the stage for the Supreme Court's definitive holding in the case of Marvin. So let's talk a little bit about what Marvin entailed, what happened in that case. Marvin was a case where the singer, Michelle Triola Marvin, who was in a 6-year cohabiting relationship with the famous actor Lee Marvin, filed a civil suit for breach of contract. Michelle and Lee had lived together for 6 years, and when their relationship ended, Lee kicked Michelle out of the house, and after some point, he stopped paying her any support. Michelle alleged that she and Lee had entered into an oral agreement wherein she had promised to act as his companion, his confidant, his partner. She had given up what she claimed was a promising career as an entertainer to do that. And in turn, Lee had promised to financially support her for the remainder of her life and to divide the property that he had acquired during the relationship evenly. What ends up happening is the trial court grants Lee's motion for judgment on the pleadings. The Supreme Court finds that it was error to do that, reverses and remands, and says that the facts as alleged by Michelle, if they're accepted as true, state a viable cause of action for breach of contract. The Supreme Court in Marvin definitively finds that non-marital cohabiting romantic partners can enter into contracts, whether those contracts are oral or written, expressed or implied, ordering their economic affairs any way they deem appropriate, so long as the contract is not explicitly and inseverably resting on the consideration of meretricious sexual services. The court in Marvin also found that if there's no express agreement, the court should look at the conduct of the parties to see if their behavior evidences an implied agreement or some kind of tacit understanding between them. The court also noted that these non-marital cohabitants can seek equitable remedies, things like quantum merit, constructive trust, and many others. Finally, as I mentioned, the court held that Marvin claims are strictly civil claims. They are not governed by the family code. I know Daniel's going to get a little bit more into this later on, but that's important to note because unlike family law claims that are tried in front of a judicial officer, Marvin claims often are tried in front of a jury. Interestingly enough, the court, when ruling on the merits of Michelle's claim, found that she had failed to establish the existence of an oral agreement, of an enforceable oral agreement. I think this is important because it's indicative of the difficulties faced by Marvin plaintiffs in bringing a successful action. Here we have the seminal case that sets forth the law on these types of claims, and even the plaintiff in this case proved to be unsuccessful. What we're hoping to do today is give everybody enough guidance so that you're able to file a claim and not end up in the situation that Michelle Triola found herself in. So before I get a little bit deeper into the legal theories behind Marvin claims, I want to note that there is an important distinction between Marvin claims and putative spouse claims. I find that many people tend to conflate the two, understandably, because there are similarities, but the distinction, I believe, is important. So both of these claims are premised on the lack of a valid marriage. However, a putative spouse claim involves at least one party to an invalid marriage who has a subjective good faith belief that the marriage was in fact valid. Putative spouse claims, unlike Marvin claims, are governed by the family code, so they're brought in family court. What this means practically is that when you're doing the initial client intake interview, it's a good idea to try to figure out at first, does the client have a potential putative spouse claim? Did either of the parties have a reasonable belief in a valid marriage? If you determine that that's not the case, then at that point, you can turn to see if there is a viable Marvin claim to pursue. So Marvin actions are contract claims, and the legal theories behind Marvin actions are breach of an express contract, oral or written, breach of an implied in fact contract, meaning a contract that can be inferred from the behavior of the parties, and then breach of an implied in law contract or an action to recover the reasonable value of services rendered, less the support that's been provided. Typically speaking, written contracts or Marvin claims based on the breach of a written contract are not that common. Oral agreements are more common, although they can be difficult to prove because you have to determine or you have to establish the existence of an enforceable contract that has sufficiently specific terms. Another distinction, and Daniel can talk a little bit more about this, is the difference between oral and written agreements is the shorter statute of limitations that's applicable, and as well as the statute of frauds that oral agreements are subject to. Daniel, I don't know if you want to add to that and what the implications are.
Yeah, I'm happy to give a quick pointer on that. The civil litigators in the room are probably aware of that. Under California law, oral agreements are subject to a 2-year statute of limitation. Written agreements are subject to a 4-year statute of limitation. So, whether you're suing on an oral or written agreement, it's important to get that sorted out at the outset of the case. Later on, I'm going to talk a little bit about accrual of claims. And I'll also get into the statute of frauds a little bit, but statute of frauds issues do arise in this context frequently because Marvin claims involve claims to ownership or other interests in property, which, as I'm sure a lot of you are aware, are generally subject to the statute of frauds in California. So I'll kick it back to Suzanna, and she can keep going with her presentation.
So there's oral contracts, there's written contracts, and then in many Marvin actions, these cases are going to be based on the breach of an implied agreement. Meaning, did the parties' behavior during the relationship suggest that there is a binding contract between them, even though that contract may not have been expressed in writing or orally? What's important here is that the parties' conduct has to be consistent with the specific agreement that the moving party is seeking to enforce. So let's say the plaintiff claims that there is an implied agreement for financial support, for lifetime support. Then you're going to need to look at whether their conduct throughout the relationship demonstrates that there was such an agreement. For example, you're going to want to see whether the other party paid for the expenses of the moving party, whether the moving party stopped working, gave up a career, and was relying on the non-moving party for payment of her expenses, things like that. Even though the existence of a marriage-like relationship, meaning the parties lived together, they acted as husband and wife, or they acted as a married couple, their friends and family refer to them as a married couple, even though that is relevant to the existence of an implied agreement, it's not sufficient on its own, and you're going to need to look at the specific agreement that's being alleged to see if the behavior aligns with that agreement. Whether you're assessing the viability of a potential Marvin claim or you're on the other side putting together your defense to one, there's some key things that you want to look out for in Marvin actions. First and foremost is cohabitation. A Marvin claim needs a stable relationship that arises out of cohabitation. Technically speaking, cohabitation is not a prerequisite to a Marvin claim, but effectively lack of cohabitation is going to defeat the claim. So it is effectively essential. There is one case in California, and I believe this case is on the Marvin cheat sheet that's been handed out to everybody, Cochran v. Cochran, that found that part-time cohabitation may be sufficient depending on the circumstances of the parties and the other factors involved. In addition to cohabitation, a Marvin claim is a contract claim. So you're looking for an agreement. Usually that agreement is going to be to share property and/or it's going to be for payment of financial support. What's important here is that the terms of the agreement need to be sufficiently definite in order to state a cause of action for breach of contract. A Marvin plaintiff is going to have to prove the existence of the agreement by a preponderance of the evidence. And as Daniel will talk about more later on, vagueness is a potential defense to a Marvin claim. Again, Marvin claims are based in contract, so there needs to also be lawful consideration. In the Marvin context, what that means is that the consideration cannot be inseparably based on sexual services. The court in Marvin found that even if sexual services form a part of the consideration, so long as there's other parts of the agreement that have independent consideration, those parts of the agreement will be enforceable. Realistically, in today's world, so long as the parties are living together, so long as you have the cohabitation factor, the unlawful sexual consideration issue usually won't come up. Finally, in any Marvin action, there needs to be a breach. Breach usually occurs when the relationship ends, and this is important to note because this is the point at which your statute of limitations, depending on what kind of contract's being alleged, is going to start to run. In some situations, the breach does not occur when the parties break up. It occurs at a point later on, and that point is when the non-moving party fails to comply with the terms of the agreement or fails to perform under the contract. So, for example, in some situations, like in Marvin, the non-moving party will continue to pay financial support for a period of time after the parties break up. In that case, the breach for the agreement for support, at least, occurs when the party stops paying support. If you have an agreement for sharing property or dividing property, then the breach occurs when the non-moving party fails to do that, fails to divide the property as agreed to. So having gone through the substantive aspects of Marvin cases and understanding what these claims entail, the next step is investigating the facts of the particular case, gathering the evidence, and gathering enough information to put together a detailed complaint. The process of investigating a Marvin claim is very similar to the process in a dissolution case. So you're looking for things like financial accounts, one party, taking care of the household while the other party grew his or her career, whether the parties had children, things like that, things to enforce that the parties had a marriage-like relationship and an agreement, whether that was implied or express. As mentioned earlier, this is also the point where you want to see whether the client has a putative spouse claim versus a Marvin claim, whether you're going to be filing in family or civil court. Once you do that, you want to assess the viability of your potential Marvin action. And there's some key questions that you want to ask the client during the interview. Things like, did they have a written or oral agreement? What was the length of their relationship? Did they live together? How long? Did they have children? What was their financial situation like? Keeping in mind that a Marvin case is going to most likely be tried in front of a jury, you may also want to ask why the parties didn't get married. And Judge Feffer, I'll turn to you because I know you're going to address this topic a little bit more later on if you want to add to that.
Right. Well, these are all important considerations. Again, you're going to be in civil court where there's a potential for a jury. Again, part of client interview is, do you want your client, either on the plaintiff or the defense side to go before the jury? Of course, family law matters are all court trials, but these are important considerations. So that is going to be a question. Why didn't you get married? And again, we all, I mean, I know people like this, and everyone may know someone like this of, I don't want to get married because, if we get divorced, my ex is going to take half of my stuff, or I got burned in my divorce, so I'm never getting married again because I don't want, half of my stuff, of my earnings to go to my ex. So some people will, and this is kind of a defense to Marvin cases, we didn't get married because I did not agree to support my ex. I'm very generous during the relationship. I bestow, gifts and jewelry and trips and even a car. But when it's over, it's over. And I never agree to support. And that's why we didn't get married. So these type of things do come up. So these are important things to talk about on an intake on the plaintiff side or even on the defense side.
So in addition to gathering the information, and as Judge Feffer said, figuring out, is this a case that I want to take? Is this client going to testify well in front of a jury? You also want to figure out, especially in an oral agreement or implied agreement situation, what documents the client has that support the claim. So for example, if the client is claiming that there was an agreement for financial support, you're going to want to look at joint bank statements, joint credit card statements, receipts of expenses being paid by one party for both parties, things that evidence that there was an understanding or an agreement that one party was going to support the other. If the alleged agreement is for sharing property, then you may want to see if there are title documents, if there are homeowners insurance policies where both parties are named. Estate planning documents are often helpful if one party is named as a beneficiary and is going to receive all these assets. That may tend to prove the existence of an agreement to share property. Judge Feffer will talk about this as well later on. It may also tend to prove go against the existence of an agreement, as you'll see. Regardless, in putting together the complaint, you want to plead as much detail as possible so that you avoid dispositive motions that may be filed by the defense. Obviously, if you're the defense, what you want to do is gather enough information, supporting documents, to think of what motions you can file, whether that be a demurrer, a motion for summary judgment to defeat the claim at the outset. Finally, you also want to think about what equitable remedies you can request in the complaint. These things include quantum meruit, like we discussed, equitable estoppel, a constructive trust to be placed on one of the assets so that there's no unjust enrichment to the party who's holding the asset. These equitable remedies are important in Marvin claims because of how difficult it can be to prove the existence of an oral or an implied agreement. So you want to make sure that you assess the facts and you include as many equitable remedies as are applicable. The court in Marvin did note that courts should, feel free to fashion new equitable remedies if the existing remedies are not adequate to address the party's expectations. Despite the court's holding in Marvin, what's happened is that courts in Marvin cases have usually shied away from fashioning new equitable remedies. Nonetheless, when you're putting together the complaint, make sure to think about all the facts as they are, all the documents that you have, and include, in addition to the breach of contract, claims, any equitable remedies that can assist your client's case. So now that we've gone through the substantive aspects, Daniel, I'll turn to you for the next part of the presentation.
Thank you very much, Suzanna. Suzanna covered a lot of the substantive rules. I want to focus a little bit more on some of the practical aspects and some of the stuff that I've seen in my experience litigating these cases. And for that reason, one of the things I want to start off with first is some key distinctions that arise between family courts and civil courts that family law practitioners will run into. And that's just because a lot of the time these Marvin claims arise in the context of some sort of a family law dispute. And so I want to make sure that all you family law attorneys out there are prepared for what the differences are. So as Suzanna mentioned before, Marvin claims are civil claims, so they're governed by the Code of Civil Procedure, not the Family Code. And practically speaking, what that means, first of all, is that you don't have available to you the fee shifting provisions that you would have in a family court, in a family law action. So for example, under Family Code Section 2030, you don't have available to you Family Code Section 271 sanctions, and you can't go and take out a flarple on your client's property to help secure payment in the case. And what that means is, just as is the case in almost every other civil case that practitioners deal with, is that your client is going to have to pay their own way in the litigation or enter into an appropriate contingent fee agreement. And that changes, I think, for a lot of practitioners, the importance of claim evaluation at the outset of the case. And I find I do spend more time with that when I'm dealing with plaintiffs, because I want to avoid Pyrrhic victory for my clients. The Marvin cases can get expensive, and I want to make sure that there's some sort of recovery for them at the end. So it becomes really important, again, to look at, okay, what are the assets at issue? If you're a plaintiff, if you're representing a plaintiff, what's the potential recovery? And if they win, what is that victory going to look like? Another thing that is important to remember, and again, is a distinction from family law cases, is that you don't have the benefit of the automatic temporary restraining orders that attach at the outset of a family law action. So, in some sense, that can make it more difficult to prevent the dissipation of assets or get orders for resulting trust or freeze orders. The standard procedures and standards that apply in a civil case for preliminary injunctive relief apply in a Marvin case. So you're going to have to show irreparable injury, that the legal remedies aren't sufficient. You're going to have to show likelihood of success on the merits. And the corollary to that, of course, is also that in almost all cases in a Marvin action, you will not be able to obtain an interim order for monetary relief, like a spousal support order. Another big distinction that comes up a lot that I've seen is that the scope of discovery in civil cases and family law cases is there's a fairly substantial difference in the scope of discovery. So I think most family law lawyers who are out there and used to litigating dissolution cases are accustomed to pretty wide-ranging and probing financial discovery. You should not take that as a given in a Marvin case. So for example, one that comes up right off the bat is that the taxpayer privilege applies in a Marvin action, whereas it would not in a marital dissolution action. And so, for that reason, as you're evaluating the claims and putting together a complaint, it does behoove you, I think, to really do a good job to focus on tying the claims directly into the type of financial discovery you're going to need. That way, down the line, you can get the documents you want to support your claim, and you're not going to run into as many issues in that respect. So during her presentation, Suzanna mentioned a number of different times what potential dispositive motions and the litigation approach in Marvin claims. Generally speaking, I think a lot of civil litigators are going to be used to this. It's going to be similar to what you would expect in any breach of contract action. Of course, in most Marvin cases, you're dealing with an oral contract or an implied in fact contract. There are some key factual differences here, though. The first of which is that as a general matter, courts tend to be a little bit more lenient on pleading Marvin cases. And one of the reasons for that can be found in the Morton v. Dillingham case, which is listed in our handouts. Generally, the situation that you're faced with in a Marvin claim is you have someone who's been in a long-term relationship who's incurred a detriment to stay in the relationship. And for that reason, they're going to get some level of lenience in terms of pleading their claims and proving them up. One of those is, for example, the statute of frauds issue. Normally, you would expect if someone is asserting a claim based on a breach of contract that involves an interest in real property in California, that the statute of frauds would apply. The defendant could then say, well, you can't enforce an oral agreement for ownership of property, so you're out of luck. Morton v. Dillingham says, nope, that's not the case. You can be stopped from asserting the statute of frauds defense in Marvin actions, provided that the factual predicate for that estoppel is present. So as you're developing your case on the plaintiff's side and the defense side, you want to make sure that you're developing those issues. So if you're the plaintiff, you want to be able to plead and prove that you incurred a detriment in reliance on a promise. If you're the defendant, you want to be able to serve discovery and test the basis for that estoppel defense. Delving a bit more into some of the other defenses and also hopefully to address some of the other questions I've seen pop up. So a key issue that practitioners should be aware of are statute of limitations issues. As Suzanna mentioned, Marvin claims accrue normally under two circumstances. First is upon breakup. The second one is upon failure to perform. And most of the time they coincide with each other. So if you have someone who's trying to enforce an agreement, say, hey, you promised me that if we break up, you will support me for the rest of my life. Well, if there's a breakup and then the other party doesn't start paying support immediately, well, you've got a breach, claim is accrued. And then depending on the type of claim, you have a couple of years to file. So if you have a written agreement, 4 years to standard statute of limitations. If you're suing on an oral or implied agreement, which is going to be in most cases, you got 2 years from the breach. And if you're suing on a quantum merit claim or something, it's going to be 2 years as well. The statute of frauds issue is something I already addressed. It's under California Civil Code section 1624. Certain contracts have to be in writing. In this context, again, most of the time it's going to come up involving agreements that touch on real property rights. It's an affirmative defense, so most of the time it's not going to be great to raise it in a demur, particularly given the law in Morton v. Dillingham. Most of the time a statute of frauds demur is not going to be successful. And really, this is more something to develop through discovery over the course of the case. Another defense that Suzanna raised, or an issue that Suzanna raised, is lack of consideration and a closely associated contract defense, which would be unenforceability due to public policy. In this context, in the Marvin, when you're dealing with Marvin claims, it really is most of the time proving that the consideration for the agreement is meretricious, is the rendering of meretricious sexual services. Now, if you look at the case law on this issue, it's shifted a fair amount over the years, and the recent cases really don't touch on this all that often. The most famous one is the Daly case, which in that case held that, so it's a 1981 case involving an oral cohabitation agreement between two men. And the court there held that the agreement rested entirely on the rendering of meretricious sexual services, and so it wasn't enforceable. I personally believe that probably, that case was a product of its time, and that you're less likely to see courts coming to a similar decision these days. As Suzanna mentioned, really, if you have some sort of cohabitation, the consideration is going to be there. But also, on these issues, I don't want to speak out of turn. Judge Feffer has a lot of judicial experience. I'd be really interested to hear, her thoughts on that particular issue. There were a number of questions raised regarding potential other defenses related to marriages involving the same person. If you review the cases that we've kind of highlighted on our cheat sheet, if a Marvin claim accrues before marriage, then the subsequent marriage doesn't defeat it. So a fairly frequent fact pattern that I've seen in my practice is we have parties who date for a period of time, they're cohabiting for a period of time, then they get married, then there's a divorce. In those cases, there could be a viable Marvin claim that relates to the period of time, the period of the relationship that predates the marriage. And it's really something to watch out for, because it's possible that, if you have a short marriage that follows a very long period of non-marital cohabitation, the potential recovery for a Marvin claim in that circumstance may be significantly greater than what you'd be able to get in a marital dissolution action. And that's really something to consider. I've noticed also a number of people raising issues, asking questions that are kind of probate related. If you go through the case law on this, you'll see that actually a lot of cases that discuss Marvin claims arise in the probate context. And so a frequent fact pattern that you have is you have two people who, for whatever reason, haven't gotten married. One of the persons dies. They have a will, but they didn't provide for their life partner in the will. And so then there's a dispute that arises when the will is probated. The surviving life partner is saying, look, she promised me the house when she died, or she told me repeatedly that I had an interest in the house, or the house was partially mine. What ends up happening is the Marvin claim becomes a creditor's claim in the trust or the estate administration subsequently. So those are potentially viable, but you still have the same. Then you have not just the civil litigation issues, you have the trust and estates issues and the family law issues arising as well. So it gets a little complicated. I find it very interesting, but it's absolutely something that comes up a fair amount. There are a number of issues of proof that Marvin claimants face. I want to touch on just one briefly, which is the standard of proof, the evidence standard that you need to have. Because Marvin claims are civil claims, normally you have the preponderance of the evidence standard, unless you're dealing with claims for real property. Then the claims are subject to the clear and convincing evidence standard, and that's discussed in the Cahill v. Finch case, which is listed in our handout. I want to make sure that we have time for questions at the end of this, and I'm seeing a lot of stuff coming up. I just want to invite all of you to contact us if you have anything that we didn't address. Happy to talk to anyone after this, by email or phone. It's a really interesting area of law with lots of different overlaps, and I love discussing it. So on that note, I'm going to hand things over to Judge Feffer for the judges and neutral's view on these types of claims.
Great. Thank you, Daniel. I know we've had a lot of great questions come up in the Q&A, so I hope we can hit on as many as we can. So the first thing, again, it's a civil case, not a family law case. That being said, it's important I mean, in every case you have, Marvin or otherwise, but it's important to know your judge's background. And, speaking to the LA Superior Court experience versus other courts, does your civil judge who's assigned the case have any family law background at all? So whether it's as a litigator or as a judge, and there are many judges, and I'm one of them from LA Superior Court, spent a number of years in family law and then had, unlimited civil assignment who got these type of cases. That's important to know because at least in LA, if you want to be a family law judge, you can be a family law judge. So, and when I had my family law assignment, several civil judges are, oh, I'm so glad you're doing that. I don't want to deal with it, the bickering and the fighting. So keep that in mind of what is your judge's background. Your judge may be completely unfamiliar with family law or may have family law experience. And so one thing that I think is fairly constant with probably most of the judges, we've been hitting on the need to be specific in the pleadings, and we'll hit on that a little bit more. And that is important in this case, but there's specificity of pleadings. And then there's what everyone calls TMI, right? I think we know the difference, too much information, kind of like when you read about celebrity divorces in the newspaper and there's like too much information. So your civil judge doesn't want to know the gory details of the relationship. So it's a civil case. So pleaded of, met, and if there's cohabitation, they moved in to this residence, and and what was the promise? What were the nature of the promise? It wasn't, oh, agree to support me the rest of my life. Like what? Well, when was that? We're going to live together forever, and 2 years into the relationship, the specific promise was made, or whatever it is. Your pleadings need to be very specific about kind of the dates and times and the nature of the promise and what was it. I'll take care of you, or we have this home in, we've got a home on the beach in Newport Beach, and we've got our home in Beverly Hills, right? And I know you always love Newport Beach, so the Newport Beach home is yours. No matter what happens, it's yours, right? So what is the nature of the promise? So be specific, but not the TMI of like the family law juicy stuff. Your civil judge will not want to hear kind of the gory details, if you will. And I think we're all adults. I think we know what that is, but there are many family law cases where there's just inappropriate information that's designed to kind of inflame the judge if I don't like you. And of course, every judge has a case where you don't have to like the litigants. Is there a valid contract? Yes or no? Is there a breach of contract? Yes or no? It's not whether I personally like you, or even in a car accident case. You may really dislike the plaintiff and really love the defendant. But if the defendant is liable, that's the way the case, the outcome will be, not on personalities. So have those facts there. And again, when you say, well, judges can sort it out. Well, it's not a great analogy, but every civil judge will have had like a partition case amongst siblings, right? Where it's the family, mom and dad died, and you've got 2, 3, however many siblings dividing it up. Yes, it's a civil case for a petition, but it's really kind of a probate case with the emotions of, well, mom liked you more, dad was more generous with his time and, coached her little league team and not mine, or whatever it is. So focus on the contract aspect of the case. And again, as far as pleading, we kind of hit on it. Why aren't the parties married? Well, that may be something that, the plaintiff, you should put in there. The parties agreed not to get married because, maybe one side was married before and had kids and whatever it is, that might be worth putting in there because it's going to come up. And again, that's a great defense, right? We didn't get married because there's no way I ever agreed to support or give anything to the other side once the relationship ended. So that might be something to deal with up front. But focus on the contract aspect. A number of the questions in the Q&A are, is this sufficient or is that sufficient? Again, your civil judge who's assigned your Marvin case might not have had, a ton of Marvin cases. I mean, they're even in LA, and I was downtown for many years in civil. You don't get a ton of Marvin cases on the docket. And those you do, many of them resolve fairly quickly. So, maybe there's a case management conference, but, there aren't a lot of Marvin trials in the LA Superior Court. But every judge will have had many, many breach of oral contract cases, partnership dissolution. So this is a partnership dissolution. It's just they live together as a romantic relationship that is no longer. But I mean, I can't count how many trials I'd had of, we had the, not a Marvin case, we had this oral agreement, or, we're both doctors and we formed this medical corporation, and we had an oral partnership agreement to share 50-50 in the profits. Well, the judge has to decide that case, or the jury. So, why didn't you put it in writing? You're both doctors, you should know better, right? So every judge has had breach of oral agreement, breach of oral contract cases, partnership dissolution cases. So kind of focus on that. And so, well, is this type of evidence sufficient? Well, again, maybe you have two doctors who split up their medical practice and one's claiming it was 50-50 and the other's not. Well, what is your proof? Is your proof in any particular case sufficient? So this is a completely case-by-case analysis. Some of the questions are, well, is it judicial estoppel? For instance, one person puts on the tax return, a different primary address. Is that conclusive? Well, I mean, unless there's case law on point, it would be up to the court. But like in family law, when I was there, 2008 to 2012, it was right after the Great Recession. There are many people who, I can't pay spousal support, right? Because my income is $5,000 a month. Well, here's your tax return, that you submitted a mortgage application saying that you made 30 grand a month. Oh, well, right. Is that conclusive? Is that estoppel? So any evidence you have either on the plaintiff side or defense side, those are things you should look at when evaluating the case and whether to take it to trial. What documents, and then Suzanna said, what documents back up what they're saying? It's an oral agreement, but here we have a tax return. You say we live together, but here's a tax return saying we lived apart. So these are all the things you marshal together. Again, the courts want to get it right and to be fair. Juries, again, and that's why we emphasize these are jury trials. If you have equitable issues, you can invoke the equity first doctrine and, perhaps have, if the court agrees, to bifurcate the equitable issues first. Some judges do equitable issues first, bifurcated, others wait until after the jury trial, but that's worth a discussion with your judge. But a lot of this is, again, what will the jury do? And so when you're deciding whether to have a bench trial or a jury trial, is the judge going to like your client? Is the jury going to like your client? Everyone has, a preconception about Marvin cases. It's just the way it is. These people live together and, I want lifetime support for, in family law courts, of course, we have community property. So as much as some litigants would try to come to court and say, she was a lousy wife or he is a lousy husband, it's like 50-50, right? Community property, it's presumed. But there is, as Suzanna and Daniel said, there is a quantum meruit, kind of like an equitable component of this, of what did you put into this relationship other than the meretricious sexual services? What did you do to contribute to the household? Did you have a joint checking account where you both worked and you both put your income into it? You bought the car and you bought the house, and what is it? So because of the nature of the Marvin claim of what did you put into the relationship, there is going to be an aspect of fairness that the jurors will keep in the back of their mind. So think of how that will translate, in court if you decide to try the case. I don't know, Daniel, if there's anything you wanted to add in that respect.
I mean, I just to highlight again, that one point. I think to some extent, a lot of the judges who have some exposure to the family law type of cases, they may be immunized for these types of issues. It's not going to faze them as much when people start throwing around all kinds of allegations that may not be central to the claims that you're dealing with, when you're getting into that TMI zone that Judge Feffer was talking about. But once you get into the jury realm, I think these types of issues really become of a greater concern, where you're starting to think about, well, what does your average citizen here in LA, for example, think about this situation where you have people who weren't married and they, dated for a while and lived together for a while, and now all of a sudden he wants half of everything based on an oral agreement, even though he didn't work and he didn't contribute anything. He was just kind of hanging out. Some judges, I think in particular, family law judges may be able to kind of look at, may be able to sequester whatever biases they have and come to an equitable ruling that's going to be fair and do the right thing. I think juries may be more susceptible to being swayed one way or another. And so when you're thinking about presentation, particularly in front of the jury, the things, all of us as civil practitioners, you know, who've done jury trials, these things come to the forefront. You always want to think about, okay, how is my client going to present? Are they credible? Does it seem like they're being reasonable? Is there a compelling story that you can present to a jury about what they want is fair? And it's really important to start developing that both from the plaintiff side and the defense side, right from the outset of the case. You know, really look at it that way. You know, not just to the judge, but also to a jury. Why is the outcome that I want fair? Why is it the right thing to do in this case?
And that's where I think the lawyers also, I mean, you know, you're the advocate, but you need to think about how your client is going to do on cross-examination. And I mean, just speaking for myself only, I can't tell you how many times I'd sit there during jury trial and think, first, like, the parties are probably wishing that they'd settle the case like right around now, because it's getting pretty brutal. You have to sit there, you know, no matter what the other side says about you, you have to sit there, you know, no rolling the eyes and like, oh, the dramatics. But there's so many times where the plaintiff will be on the stand and they're nailing it. And of course, because everyone nails it on direct, right? It's your client. It's like your lawyer giving you the questions that you're going to answer. And I'm thinking, why didn't this case settle? There's got to be a reason, you know, because this plaintiff is awesome, right? And then here comes the defense cross and the case falls apart, or the other way around. You know, defense is like, wow, you know, and then the plaintiff's cross. So cases are made or broken on cross-examination. I think every civil litigator realizes the importance of that. So everyone's great. And, you know, you hear, well, so-and-so gave compelling testimony. Yes, because it's his or her own lawyer giving the questions that they've rehearsed the answers to. And, oh, we did this. And then it's like the cross. So how is your client going to do on cross? And is it a case, you know, given that, is it a case that you really do want to take to court? I want to speak very quickly about resolving the cases. And it's like we've kind of been hitting that Marvin cases are civil cases, but in the judge's mind, and I think in a lot of the jurors' minds, it's a family law case, just kind of like how partition cases can really kind of be probate cases. To kind of, you know, resolve that, of sometimes the partition cases, you really have to get into, you know, mom favored you or favored me, or dad did it, you know, all, you know, you got grandma's china and you know, I took care of dad and you never went to a single appointment and visit in the hospital, all that stuff. You know, you need to get through that to settle some of these cases with the emotion. And like with the Marvin case, you know, what's driving it? You know, is it, you know, they really thought they'd be together forever. And, you know, one cheated on the other, or one, you know, broke their heart or did something that, you know, I mean, we're all humans. We've all seen how many different ways relationships can be screwed up, and some more humiliating than others. Or so, you know, so again, when you're in court, it's a civil case, right? Neutral, calm, you know, not the, you know, low cut, you know, but in a mediation setting, it's you do have to get into the dynamics of what's really going on here. Why is this case really being brought? Are there someone's hurt feelings? And maybe it's, you know, I'm asking for the moon, and really all I want is this. All I want is, you know, just this amount for this amount of time, or, you know, you really promised me this, and, you know, you betrayed me, you broke the promise, whatever it is. See if there's some creative solution there. Maybe it's, you know, you really treated my kid as your own kid, and you did promise that you would pay for my kid's college tuition, and it's not about me. That's really all I want. So even going beyond the emotional aspect, as Daniel said, because there's no fee shifting, and these are often contingent fee cases, you know, that's part of the leverage as well too. Of course, in family law, there's fee shifting that could occur, but here, you know, who's financing the case? Those are all considerations for settling the lawsuit, and that could come up. But again, you could be creative in trying to resolve the case. Sometimes it's not just about the money. Sometimes there are apologies or different things, but you do have to get behind, like, why are they really litigating? Why this animosity that there's, and when you kind of recognize that, that could go a long way towards resolving the claims. I know, Suzanna, if you had any thoughts on that subject.
Yeah, I think that comes up often in family law as well. Like when we do a VSC, for example, you realize that, these parties may be pushing a certain request and, spending all this money on litigation, but what they really want is something else. And I think that that is really translatable to Marvin cases as well, because usually it's a similar situation. These people have been together for a long time. Something has happened, where one or both of them is hurt, especially if there's children. So I think it's trying to figure out, what is the real issue here and doing it in a cost-effective manner, because like Judge Feffer said, you're not going to get a, Family Code 2030 or Family Code 271 sanctions-based attorney's fee order in a Marvin action.
Absolutely. Daniel, if you had any thoughts on that as well.
Oh, yeah, I mean, you guys handle it great. I don't have anything else I want to add to that.
They're very complicated cases, like factually. It's good. See if there are any other issues that were raised on the Q&A. I think we've covered.
I saw a number of questions discussing kind of cohabitation agreements or pre-cohab agreements. Again, it's going to be fact-based. There's going to be fact-based, and it's going to be relevant to whether a Marvin claim exists or not. One of the interesting things, particularly in cases where you have marriage subsequent to a period of cohabitation, is whether there's a prenuptial agreement that includes Marvin waivers or not. There's an issue that I've wanted to try and get involved with that I haven't had the opportunity yet, but I strongly suspect that a prenup in that case that doesn't include a Marvin waiver, but is properly integrated and detailed enough, may actually end up invalidating potential Marvin claims as well. But that's just my opinion. I don't have anything to back it up.
One other thing I wanted to add, going back to mediation, and again, I see this in all family law cases. I have some sex abuse cases that it's helpful if the attorney can tell the mediator, preferably in the pre-mediation phone call, if you think Zoom format is good or in person. I mean, obviously you could sign up for a Zoom mediation or an in-person, but I've had some where, everyone wants to be in person, which is fine. And I greatly enjoy doing in-person mediations. There's a huge benefit to them. But sometimes if the emotions are just, it's still too raw, that Zoom might be appropriate. You don't want, an all-night session to blow up because, the parties run into each other, in the hallway, going to the restroom, and now it's on again. So I think part of what's helpful to communicate to mediators is maybe we should do this by Zoom, or maybe in person would be, maybe all the other person wants to be is heard, and show me some respect, and, being in person and saying, gee, I'm sorry. I really didn't, I didn't handle that well. That being communicated in person may be more powerful. And many of these can be mediated over several sessions. If you don't get it done in one night. So, sometimes the parties are still kind of their defenses up, but then the next day they go, yeah, maybe it's time, but they want to, appear strong and not fold and cave and settle. So sometimes you can't resolve it in one session, but follow-up can help with that.
Thank you to our speakers. We are right at the 1 o'clock marker when we said we would wrap up today. If there are any remaining questions, please feel free to submit those in the post-event survey. I do have a quick video to wrap us out. And as a reminder, you'll be directed to a short survey when you log off of this Zoom. We would really appreciate your feedback about future programming and any feedback for our speakers and for ADR Services, Inc. as well. Thank you so very much to all of our speakers today for, as somebody mentioned, taking the Marvin cases and making them easier to digest because these are challenging topics. Thank you so very much for your time. And with that, I will go ahead and share a quick video for everybody and close us out.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront. Woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.